Okay, I now call the meeting of the Code Enforcement Special Magistrate to order. Please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, welcome to the Hillsborough County Code Enforcement Special Magistrate hearing. When addressing the magistrate, please state your name, address, and speak clearly into the microphone. If you are planning to speak during this hearing, you must sign the speakers list located at the front door so your case may be called. Any person who decides to appeal the decision of the Code Enforcement Special Magistrate will need a record of the proceedings. The record is comprised of the testimony and an evidence on which an appeal is based. It is your responsibility to ensure that the verbatim record of the proceedings is made. By law, you have 30 days from the date of the order to appeal the magistrate's decision to the circuit court. Presentations by the county respondents and opposition must be kept to a maximum of 10 minutes each. The basic process for this hearing is as follows. Your case will be, CBS Code Enforcement staff will conduct the oath of witness. Your case will be announced. Staff will present the evidence on your case. You will be allowed to rebut that evidence and explain what has occurred. I will close the hearing and announce a decision. All decisions are based on the gravity of the violation, the action taken by the violator, and the violator's history. I may ask questions and allow other witness testimony if necessary. Depending on my order, the code enforcement staff may later have to conduct an inspection to see if you complied. If the staff believes you have not complied, you will receive a notice in the mail. By law, you have 10 days to contest that notice, otherwise it will be considered correct and a lien may be filed against the property. If you have any questions, these rules are outlined in Hillsborough County Code and Ordinance and Laws, Chapter 14, Article 2, Section 14. Before we begin, please silence all electronic devices. At this point, I will now approve the meeting minutes of August 21st, 2020 and September 11th, 2020. Okay, now at this time, can the administer the oath to the defendants and witnesses?
Good morning, all county staff who will be testifying must take the oath of witness. Please stand and raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you. First case is on page 1 of your agenda, number 1, case number CE 2000-5098. The violator is 360 Customs Incorporated, and the location of the violator is on the county right-of-way. Signed in to speak on this case. If you're, okay, there he comes.
Okay, good morning. I'm Officer Charles Harwell, Hillsborough County Code Enforcement. This case was submitted to the county on April 10th, 2020. During the case cycle, we received a couple of complaints, anonymous complaints, one of which was via email. And the parcel is currently not in violation. And the violations is improper use and occupancy of the right-of-way.
Your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
And state your name and address.
Michael Huser, and I'm at 126 Edwards Avenue, Brandon, Florida, 33510.
And your relation to,
Owner.
you're the owner of
Owner-operator.
360 Customs. Thank you.
Can you please state your name for the record?
Huser? Oh, Michael Huser?
Thank you.
Okay, sir, what do you have to say?
I just wanted to state that I've been trying to police this area. It's a high traffic area, and some of these vehicles are not for my business. That's all I really wanted to state. Like, it's very difficult to keep them from parking. I've been doing the best I can. And then the other spot where I had a couple cars, I didn't realize that was the right of way. There's 2 cars in that picture that I would have moved a long time ago, but I didn't realize.
Okay, now you realize it? How long is it gonna take you to correct?
What's that?
Now that you realize, how long is it gonna take you to correct the problem?
I've moved all of those cars in that area, but like say that car in that picture right there, like when people drop their cars off, I have to try to pay attention where they park. Sometimes I don't catch them fast enough. Like periodically there's cars where I didn't put them there, but like customers put them there, or tow truck drivers dropped them there, or there's neighboring businesses that have parked cars in that area. You know, I try to police it the best I can, and I was asking the officer if they could do some no parking signs, but he said that they're not really responsible for anything like that.
Excuse me, Roger, I believe that the county is asking for a remain in compliance order for this case.
Okay, hold on a second. Well, can we ask for a remain if it's a first offense?
Yes.
Okay. Officer, what do you suggest?
I just request to remain in compliance order. Obviously, I took over the case September 21st. You notice the first photograph is dated April 10th when the case initiated, and I took it over on September. So the photos 2 through 7 are mine. I went back on December 9th. Sometime after that, they complied it. We just don't want to have to keep coming back. You know, we've got other complaints. You know, they're impeding the safe travel of pedestrian traffic on that sidewalk. You have to go into the road to go around the vehicle. So we could have a remain in compliance order.
I'm a little confused, and I asked the staff if there was not an initial violation or a fine set up, how can we do a remain?
It's, we have a violation, we investigate the violation, and it's resolved, but because of extenuating circumstances, we'll bring the case in and request that we have a remain in compliance.
Okay, we can go ahead. I'm going to go ahead and do a remain. So I rule in the case of CE 2000598 that based on the evidence presented, I find the property is again in violation of Hillsborough County Code and Ordinance as listed in staff presentation. Further, I find the property is now in compliance with this code provision in order that it remain in compliance with that code provision.
Thank you.
Thank you.
Next case is on page 2 of the agenda, number 3. Under staff reports, case number CE 1800-5494. The owner is Lawrence Properties LLC. And this case has been placed on the agenda at the request of code enforcement. Morning, council. I'll need you both to state your name and address for the record.
Benjamin Bard, Gray Robinson, PA, 401 East Jackson Street, Tampa, Florida, 33602, on behalf of code enforcement.
Jeffrey Hodges, 905 Shaded Waterway, Lutz, Florida, 33549, on behalf of Lawrence Properties.
Thank you. Will your client be testifying?
Possibly.
Now let me give him the oath then.
All right.
Barry Lawrence, Lutz, Florida, 116 Crenshaw Lake Road.
Raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Today, because the Code Enforcement Department requests that the fines in this case be unfrozen. On July 22nd, 2019, the special magistrate entered an order freezing imposing the fines, but freezing them until a decision has been rendered in case number 18 CA 10128. That was the appeal that was filed with the circuit court by Lawrence Properties. Since that date, a hearing was held on September 20th, 2019, regarding the gravity of the violations and the continuing violations, and requesting that the fines be unfrozen. Another hearing was held on November 15th, 2019. We made the arguments again about unfreezing the fines. The special magistrate determined that the fines would be unfrozen, but that same day, Lawrence Properties had filed an emergency motion for a writ of prohibition with the circuit court. There was a hearing that same day with Judge Stoddard in the circuit court regarding that emergency relief. On November 18th, 2019, the circuit court issued a stay. Throughout the proceedings in this case, Lawrence Properties has filed 4 separate cases in the circuit court regarding this issue. They filed a complaint, which was later treated as a notice of appeal, a case regarding the decision of the Value Adjustment Board, as well as the petition for a writ of prohibition that I just mentioned. On December 11th, 2019, the circuit court consolidated the 3 appeals, case numbers 19 CA 8634, 18 CA 10128, and 18 CA 11459. Subsequently, on July 20th, 2020, the circuit court issued an opinion denying the appeal and affirming the decision of the special magistrate with regard to the fines in this case. The circuit court later amended that opinion on August 11th, 2020, in order to correct certain clerical errors. In that opinion, the circuit court found that the structure in question in this case was not a bona fide agricultural property due to retail sales that are made on the property. On October 7th, 2020, the county filed a motion to lift the stay that was previously entered by Judge Stoddard in the circuit court based on the opinion entered by the circuit court on the 3 cases that were consolidated. On October 8th, 2020, Judge Stoddard granted that motion and lifted the stay. He also denied an emergency motion filed by Lawrence Properties regarding the issuance of the stay and asking for the court to enforce the stay. Lawrence Properties filed a motion for reconsideration, which was denied on the same date. What we're seeking here today is to comply with the terms of the order that was entered on July 22nd, 2019. Pursuant to that order, the special magistrate issued that the fines were frozen as of 2/8/2019 and shall remain frozen until a decision has been rendered on appeal case number 18 CA 10128. That decision has been rendered, and the decision of the special magistrate has been affirmed. As such, the fine should be unfrozen pursuant to the clear terms of the order denying contest issued on July 22nd. This has made Counsel for Lawrence Properties, Mr. Hodges, has made the same arguments several times in many different forms regarding this issue. He's made them again to the second DCA at this time, but there's been no ruling entered. He made the same arguments to Judge Stoddard when he filed the motion to enforce the stay. His motion for reconsideration, Judge Stoddard denied those motions and specifically lifted the stay. But the arguments that he's made before that we addressed previously at the hearing back in November of 2019 was that the special magistrate does not have jurisdiction as a result of Florida Rule of Appellate Procedure 9.600. That rule does not apply here in terms of the relief that we're requesting. One, we're only requesting that the special magistrate unfreeze the fines as dictated in the order because it was pending the decision in the circuit court, and that circuit court has been rendered. Even if it were to be seen as modifying the stay, that's specifically allowed by Florida Rule of Appellate Procedure 9.130. It gives continuing jurisdiction to lower tribunals and in fact directs parties to go to the lower tribunal regarding issues related to a stay. Counsel for Lawrence Properties has cited several cases stating that lower tribunals do not have jurisdiction once a notice of appeal has been filed. First, there's been no notice of appeal. A petition for writ of certiorari has been filed so far with the second DCA. That is not the same issue. He's requesting permission to appeal, and that permission has not been granted. Furthermore, the case law that he cited has been overruled and receded from, specifically in Westgate Properties, and courts have routinely held that issues that are not related to the substantive findings in a final order, which are not the issues on appeal, can be ruled upon by a lower tribunal. With regard to this case, we're not trying to change anything with regard to the decision that was entered in the final order or the substance of the issues that are before appeal. The substance of the issues on appeal with his petition of writ of certiorari to the second DCA is the interpretation of the statute and whether he qualifies as an agricultural property. The freezing of the fines and the continuation of the fines are not before the appeal and will not be affected if the fines are unfrozen. As such, the special magistrate clearly has jurisdiction to unfreeze the fines pursuant to the terms of his own order, pursuant to Rule 9.310 and applicable case law. The stay that was entered by the circuit court has expired and has been specifically lifted. Counsel for Lawrence Properties' arguments have been specifically rejected by the circuit court in that regard. If the fines are to remain frozen, Lawrence will continue to violate the code. He'll continue to flout the code, and there will be no consequence for it. In addition, based on the litigation behavior that we've seen so far, Lawrence Properties will continue to file frivolous appeals in an effort to escape the consequence of the fines and try to get an automatic stay to which he's not entitled. In order to get a stay, he would have to go to the circuit court and prove that he has a likelihood that the second DCA will accept jurisdiction, that he's got a likelihood of success on the merits, that there's a likelihood of harm if there's no stay, and it's not remediable. Here, the harm is specifically remediable because it's a money judgment. There's nothing that will be affected if he succeeds on appeal, then there will be no fines, but the amount of the fines will be determined by the unfreezing of the fines. As to his likelihood of success on the merits, he does not have a likelihood of success on the merits. The appellate court and the circuit court issued a clear decision that based on the language of the statute, he did not qualify as a bona fide agricultural property. Additionally, under the rules governing a stay, he has no right to an automatic stay without posting a bond. If he wants a stay, then he can seek that in the circuit court with the court that issued the appellate opinion that he has now tried to appeal to the second DCA. If he wants to do that, then he should post a bond, but he can't continue to file these frivolous appeals and get an effective stay of the fines for free. They should be unfrozen pursuant to the authority that the special magistrate has and pursuant to the order denying contest issued on July 22nd.
Okay. Lawrence Properties, want to speak out?
Can you repeat that?
I couldn't hear.
Yeah, Lawrence Properties.
Oof.
Uh-oh. It sounds like some,
Roger, could you repeat that?
Yes, defendant want to go ahead and speak.
Okay. Good morning. Good morning, Magistrate Brasila. Mr. Barr wants you to overlook the fact that the circuit court did stay your order.
Can you please state your name for the record?
While the appeal was pending in circuit court. I've done that already, but it's Jeffrey Todd Hodges. The circuit court stayed the proceeding for a year while the appeal was pending in front of the circuit court. Now the appeal has moved to the second DCA. And as far as Mr. Barr's argument that a petition for certiorari is not an appeal, he's talking about a distinction without substance whatsoever. Appellate jurisdiction arose in the second DCA. The instant I filed my petition for certiorari from the circuit court appeal, and appellate jurisdiction has not been relinquished. In fact, on September 1st, the Second District Court of Appeal ordered Hillsborough County to respond to the petition for certiorari within 30 days, and Hillsborough County filed an answer brief. And now I have until the end of this month to file my reply brief. And I've got a copy of that order for everyone. And I'd like it entered into the record. And as you see at the very top, where it has the DCA case number 2D20-2476, it says LT, that's lower tribunal case number, CE 1-800-5494. Nothing could be further from the truth than to say the appellate court does not have jurisdiction over this case at this particular moment. Under Rule 9.600, the jurisdiction of a lower tribunal pending review is nil. Once the record on appeal is transmitted to the initial appellate court, the court loses, the lower tribunal loses all jurisdiction to act on anything without leave of the appellate court. And once the jurisdiction is divested, only by court order of the appellate court can the lower tribunal proceed with specifically stated matters during the pendency of the appeal. And I've got a copy of the rule for everyone. And I'd like that. Third point is that the USAA versus Smolenski case, that case, by the way, is already in the record of these proceedings. 391 Southern 2nd 355 is the ruling of the the second DCA, which is the court where this appeal is now pending, as to the efficacy of Rule 9.600. And it says that a request for relinquishment of jurisdiction to the trial court for a ruling would have been the proper method of proceeding. But because there was no relinquishment of jurisdiction by the appellate court, the lower court was without jurisdiction to enter an order. Now that case dealt with attorney's fees, in particular, post-judgment. The Supreme Court ultimately, many years later actually, changed the ruling in that case to specifically allow motions for attorney's fees in the lower tribunal to proceed without appellate court permission. And that position was affirmed by the lower courts, I believe unanimously, once the rule changed. And, but the other cases we have cited previously in this proceeding still hold true. the lower tribunal just has no jurisdiction to change the substance of a final order when the final order is pending before an appellate court. It's very simple. It's a very simple proposition of law. And I just don't understand why the Code Enforcement Department feels a need to violate these well-established jurisdictional rules instead of just letting the appeals play out. Let's see what the appellate court rules. And once we know what the appellate court rules, then either the fines will be removed or the case will be remanded, and that'll be the end of the matter. There's no appeal from the second DCA on this matter because we've already had a first-tier appeal in front of the circuit court, which did not agree with our position. Nevertheless, the case is now pending before the second DCA, and this tribunal has no jurisdiction to effect the final order. Thank you.
Trade, if I might respond.
Yes, sir.
Counsel for Lawrence Properties has entered into the record 9.600. I'd also like to enter into the record 9.500.
Please state your name for the record.
Benjamin Bard for the Code Enforcement Department. This rule gives continuing jurisdiction and specifically directs parties to go to the lower tribunal in terms of issues affecting a stay, which the freezing of the fines is effectively a stay. Additionally, as Mr. Hodges has recognized himself, the court has retreated from saying that there is no jurisdiction following a notice of appeal. There is jurisdiction for lower tribunals where it does not affect the substance of the issues that are presented on appeal. As I pointed out previously, this does not affect the substance of those issues. It's merely reflecting the clear terms of the order entered on July 22nd. We're not even seeking a change. The order itself says that these fines were only frozen until a decision was rendered by the circuit court. A decision has been rendered by the circuit court and the fine should be unfrozen. Additionally, pursuant to the rule, the special magistrate clearly has jurisdiction to do that. I'd also like to state that on the record that the cases that are referred to before, Bernstein v. Barron, 516 SO2D 1042, as well as Westgate Miami Beach Limited versus Newport Operating Company, 55 SO3D 567, clearly reflect the proposition that the lower tribunal has jurisdiction to address such matters of this type. Additionally, with regard to the petition for writ of certiorari, I never said that they didn't have the appellate jurisdiction. What I was presenting that as is their likelihood of success. One of the issues that you have to consider is whether there's a likelihood that the court will accept jurisdiction. And simply put, I don't believe they will do so here, and I don't believe they will rule in favor of Lawrence Properties on the merits. They don't have a likelihood of success on the merits or on the terms of accepting jurisdiction. And as Mr. Hodges pointed out, there's no harm in unfreezing the fines. In this case, what he said was that the appellate proceedings will play out, and if Lawrence Properties prevails, then there will be no fines. There's no harm to Lawrence Properties that can't be remedied by his appellate, petition in the appellate court. For purposes of this case, the fine should be unfrozen, because in the event that it does go all the way and he prevails, then there will be no fines. But in the meantime, as we presented at previous hearings, there are continuing violations that are harming the public. There are fines that have been imposed, and pursuant to the July 22nd order, the specific terms of it, the decision has been rendered to the circuit court and the fine should be unfrozen. I have nothing further.
Mr. Hodges, got anything?
Here, I do, Magistrate Vasala. Mr. Barr makes the disingenuous argument that you can now do what you couldn't do a month ago because we had a court order in place staying you from doing it. The reason the court order was entered was because the Code Enforcement Board and the Special Magistrate were attempting in November of last year to violate the circuit court's appellate jurisdiction. That jurisdiction has now moved upwards. It hasn't come back. There hasn't even been a mandate issued by the circuit court sending the case back. So it is crazy to suggest that somehow appellate jurisdiction is not in the district court when you see they've already issued an order on the case directing responsive briefing, and the briefing schedule will end in approximately 2 weeks. The appellate jurisdiction in the DCA is very clear. Given that, you simply cannot change the substance of the final order. It's just not allowed under Rule 9.600. Rule 9.310 has nothing to do with it. That is when you post a bond seeking a stay against execution of a judgment. And that's what Rule 9.310 deals with. It has nothing to do with the jurisdiction of the lower tribunal when an appeal is pending. Thank you.
Special Magistrate, one more thing. My argument is neither crazy nor disingenuous. The circuit court did issue a stay, but only after the special magistrate acted. That's specifically contemplated in 9.310, that if the lower tribunal doesn't grant a stay, they can move to the appellate tribunal and challenge that. Here, the circuit court entered a stay after the fines were going to be unfrozen, and then the circuit court specifically lifted that stay. For Mr. Hodges to stand here and say that we can't act because of the stay that has already been lifted is itself disingenuous. And we're not talking about changing the substance of the order. If the fines are unfrozen today, that order doesn't change at all. The order says, pending the decision in the circuit court. The circuit court's decision has been rendered and the fine should be unfrozen. This is not a substantive issue affecting the merits on the appeal. It's an ancillary issue that the case law and the rules specifically provide that you have jurisdiction to rule on. Thank you.
Mr. Hodges, anything further?
Pardon?
Anything further?
I don't think so.
Okay. Okay, at this point, I'm just going to move forward and unfreeze the fines and keep it going.
Next case is on page 1 of the agenda. Item number 2, case number CE 2000-5075. The owner is Bobby Brown. The location, 402 Blueberry Lane. We have service and no one is present.
Officer Hernando from Hillsborough County Code Enforcement. This case was submitted to us on April 10th of 2020. It has multiple complaints on it. The parcel is currently in violation and the defendant is not here. That was that. The violations are outside open storage, accumulations, inoperable vehicles, and windows and exterior doors.
Mr. Hernando, have you had conversation with the owners?
I'm sorry, sir, say again?
Have you spoken to the owners at all?
Yes, sir. We've spoken to them on multiple occasions. We served a combo notice to Mr. Brown himself in person.
Okay, what kind of response have you gotten from them?
Say again?
What kind of response
That he was going to clean up the property. I just visited the property yesterday morning where actual multiple males are living in the property, and they too stated that they were going to clean up the property. However, the property is now worse.
Okay. I'm not familiar with this area. Is this all residential area?
Yes, sir. This is RSC 6 zoning.
Okay. Hey, Mr. Hernando, I'm going to ask you, what kind of time limit do you think I should impose?
I would impose the maximum fine that you can due to the continuation of the violations and them not even making an effort to clean up the property.
Okay. Okay, I'm going to rule in the case CE 200005075 that based on the evidence presented, I find the property in violation of Hillsborough County Code and Ordinance as listed in staff presentation. Further, based on the gravity of violation, the action taken by the violator, and the violator's history, I grant 14 days to come in compliance. If compliance is not achieved by that time, the fine of $300 per day will be assessed.
Thank you, sir.
Just to confirm, that's 14 days, $3 a day.
Yes, ma'am.
The agenda.
I think there's no other business at this time. So we can go ahead and adjourn.